Well, hello everybody. We are back here again. We took a little break on these lectured notes, did some activities last week, so hopefully all that went well for you. I look forward to reading some of your guys' how you are coping and get a little bit um, understand how you guys are doing at home. I kind of like to have that personal touch. I miss you guys, so I like to hear what's going on. Um, so I look forward to reading those. Today we're going to be doing chapter 43, part 1, discrimination. The chapter 43 is ginormous. So I split it into two sections. So that will be this week's assignments will be sections 1 and or part 1 and part 2 of chapter 43, and then a couple of little activities that come out of the book. This first this first lecture notes, part 1 will be a little bit shorter, part 2 will be a little bit longer, but neither one will be ginormous. All right, so on that happy note, let's begin. So discrimination, there is about 5 different amendments out of the Constitution that really target equality. First one is the 13th Amendment, which abolished slavery. And another thing, it offered all people, all race, all, no matter your gender or your natural citizenship, wherever you were born. It also offered you the law, that you were protected under all law. 14th Amendment, citizenship to all natural-born Americans. 15th Amendment allowed all men, no matter their race, the vote. 19th Amendment gave women, no matter race, the right to vote. And the 24th Amendment outlawed poll taxes. Now, you'll know that if we step back into the Jim Crow law era, which happened after Reconstruction or Reconstruction after Civil War up until the 1965, all during that time, there's going to be Jim Crow laws. Jim Crow laws basically are the legalization of segregation. It made segregation legal. And what we're going to jump to the next slide is we're going to talk a little bit about that. So some influential court cases. First one was Plessy versus Ferguson, which is in the late 1800s. It came down and said segregation essentially is legal as long as it's separate but equal. That talked about public transportation, trains. It was okay to separate whites from blacks as long as they had equal places. Now, let's be honest. Were they actually equal? Now, I know I've talked about this in U.S. history, and we've probably talked about it in Law and Justice, and maybe even North Dakota Studies. When it came down to the Jim Crow laws and separate but equal, were they equal? Absolutely not. We always think of that iconic picture of the water fountains, and the white water fountain where whites could drink was pristine, it was clean, it was clear. And then you look at the water fountain for blacks only to drink there. It wasn't clean. It didn't look clean. It seemed to be dirty. I mean, everybody would actively, no matter who you were, would choose that clean water or the white water fountain because of the appearance of it. So no, it was not equal. So that is going to be some things that's the first really big court case, and in this case, it does not rule in favor of minorities. Next one that comes later into the 1950s is the Brown versus the Board of Education, and here talks about this was an order for all schools to be integrated. Before this time, there was some segregation. Schools were legally able to segregate, and between black schools and white schools. And now the Supreme Court says that all schools must integrate. They must allow all people, no matter what their race is, to come together in a school. And they said they must do this in a what was the legal term? but it had to be in a rapidly focused manner. Meaning you can't just say, okay, just kind of slowly go about it. Meaning, no, you had to get to work and figure out how this goes, and it should be done in an efficient and quick manner. Now, there was a lot of things that they tried to do to stop this desegregation, or to stop to integrate schools better. And there'll be about busing to help, and a lot of other things. And I feel like I am jumping ahead, because I did this. I'm talking out now. I did this. I think we're going to be talking about that in part 2. So I'm not going to go too depth into the busing situation here for Brown versus Board Education. I believe we do that in part 2. So we're going to jump on to the next Civil Rights Act. Civil Rights Act of 1964 and 1968 prohibited discrimination based on race, religion, sex, and natural origin in employment and housing. So these are 3 major ones, discrimination against that revolve around discrimination. We're going to be talking about some laws that are passed in part 2 that also are for to help desegregate or to stop discrimination. That should be a better way to say it. What is discrimination? Discrimination occurs when some people are treated differently than others because of their membership in a group. Examples are, or even they say because of their membership. It could also be a perceived membership of other people. So here, race, there isn't really a perceived, you can see whether, which race they are. Age is pretty clear. Gender is fairly clear. And religion may be a little bit more hard if you don't know exactly what there is, unless their religion has a certain clothing that they wear. Like Islam, a lot of times you can see females, not a lot of times, but if they are choosing to wear a head, a scarf on their head to show that, then you would know that they're Islam. But religion could be a little bit harder not knowing. So it may be a perceived. You see a person from maybe the Middle East, and you perceive that they're Islam. That could be a perceiving. We even go into school, and our discrimination could be against somebody who you think is some people, you may think that this person may be gay or lesbian, and some people may discriminate against that. Doesn't mean that they are. No, but that was our perceived. So I want to make you realize that discrimination can be against people who are a part of a membership in a group, or you or that person perceives that person is a part of a membership group that they feel like should be discriminated. Now, here's an interesting question, or interesting thing. Not all discrimination is legal. Okay? I'm sure that should be rephrased. Not all discrimination is illegal. Okay? So let's look at how old you need to be to get your driver's permit. Many different states are different. Here, I believe, you're going to have, I may be wrong, but I believe 16 is when you can get your driver's permit in North Dakota. Why do you think that is discrimination against 15 and younger? Is that discrimination against 13-year-olds that they can't get their driver's license? I have a feeling a lot of you, while you're listening to this, are shaking your head no. No, because why? Because the North Dakota state and all states and even the federal government probably believe, and maybe we do too, and that's good, we believe that a 12-year-old or a 13-year-old or a 14-year-old isn't mature enough to drive. They may not be physically big enough to drive, to touch the pedals, and they might not be mentally mature enough in order to make good decisions while driving. Is that discrimination? No, that is protecting. That is protecting the individual, that young child, from getting into a car, and it's also protecting other people on the road. Okay? Now, a side note is, when I was a kid, and I think it's changed, maybe not, since I lived in a rural community and I lived on a farm, I could get my driver's license at 14. So I was driving, I had my driver's license by the end of my 14th year, and 15. But that was, I know that was because of rural living. Now, the rational basis test is a test that judges will use in order to determine if there is actual discrimination here. Now, the rational basis test is a judge will uphold the law or practice if there is a rational basis for differential treatment or classification. Now, I'm just just give me a couple seconds here. I'm getting into my book here. So here's an example. A rational basis exists when there is a logical relationship between the treatment or classification of the purpose of law. For example, states require their citizens to be a certain age before they can marry. These laws discriminate against people below a certain age. However, is the discrimination unconstitutional? The reason for such a law is to ensure that those who marry are capable of accepting the responsibilities of marriage. In general, people become more responsible as they get older, so there is a rational relationship between the classification and the purpose of the law. This is the exact same thing. There's a rational basis test between you have to be a certain age in order to make good decisions, so therefore you need to be a certain age in order to get married. Also, rational basis test. You have to be a certain age to get your driver's license because as you get older, you mature more and you can make better decisions. So the idea is by age 16, you are able to make those decisions. Rational basis test. Next, you have the strict scrutiny test. This is where judges will find the law or practice unconstitutional unless the state can show a compelling reason. So, the state's going to err on, the state will err on unconstitutional. They will, unless the state can say, hey, no, this is the reason why. And if it's compelling enough, the judge will say, okay, that is fine. An example here is this is I believe, now I may be wrong, but I believe this is a hypothetical example. I have not heard of this happening in the States before, but it could have. So I don't think that I may be wrong, but I believe it's hypothetical. For example, a state law prohibited beer sales to male ages 18 to 20, but not to females, because more males have been arrested for drunk driving. Although this law served an important government purpose, reducing drunk driving, it was ruled unconstitutional. The court held that there was not a close connection between the classification and the purpose, because females were legally free to buy beer and give it to males ages 18 to 20. So the idea was the purpose was to reduce drunk driving, okay? The connection between the classification, so the classification was males 18 to 20 could not buy beer, but females could. That purpose was not directly close to that classification wasn't close to the purpose, because that classification was females could still buy and give to the males between 18 and 20. So therefore, was it really a close connection where it would actually benefit? And the law said no, it really wouldn't benefit the purpose. It would not help that purpose of lessening drunk driving because of that connection where females could give. So that was unconstitutional. Excuse me. And then we have the substantial relationship test. That means that there must be a close relationship between the law and its purpose. Yes, so here, oh man, did I do a boo-boo? Okay, so here we go. So the strict scrutiny test, now some of you may be thinking, oh my gosh, Mr. P, you are so wrong on this. And guess what? I was. Here, the substantial relationship test, it goes with that example of that the females buying beer for the 18 through 20-year-old males. There's a substantial racial relationship, and that relationship that is between that and the purpose was not there. So what I just talked about prior to this is for substantial relationship. I am sorry. My kids are upstairs above me and I can hear them pounding, so I get distracted sometimes. And there we go. So I am sorry. The substantial relationship was for this prior one. And now let's go back to the strict scrutiny test. That will be a little bit better for us. Strict scrutiny test, there must be a close relationship between a law and its purpose. No. Strict scrutiny test. Strict scrutiny test, judges will find the law or practice unconstitutional unless the state can show a compelling reason. I'm going to give you an example. This is an example of in Florida, and it has to do with certain religions. And in certain religions, it is a common practice to do animal sacrifice, okay? So we're going to talk a little bit about that, and so just be aware that that's going to be coming up here. For example, a Florida town passed a law against ritual animal sacrifices by the members of a particular religion. The law was challenged, and the Supreme Court used the strict scrutiny test. Although the government had a compelling interest in sanitation and in avoiding cruelty to animals, those interests had to be dealt with through laws applied fairly to everyone in the community, not simply by targeting the religious practices of one group. There was a non-discriminating way to say that they could not do this by not making one's religion determine whether or not the law applied. To satisfy that interest, the court determined that the ordinance was unconstitutional. So that kind of gives you an idea of the strict scrutiny test. That ordinance was unconstitutional because it could not be said that it was not going against someone's religion. Okay, and then substantial relationship, we did talk about that. I truly apologize, guys, for the last two slides. Guess what? It's not going to... if you are really confused about strict scrutiny and substantial relationship, guess what? Not the end of the world. It is not going to be on the 2 questions after this that are for your comprehension questions. And if I do a test, the test is always open book. So please, please, please don't lose sleep tonight that you do not understand which strict scrutiny and substantial relationship test, the difference between the two, because that was my fault. Okay, guys, after this, please jump down to the link. It should be Chapter 43, Part 1, Comprehension Questions, and there is only 2, I repeat, only 2 questions that you have to answer. After that, you will be doing an activity, which is very simple, just out of your book. I've been really finding that they have some great activities to kind of help you understand different things of our book. And then after that, you'll jump down and listen to Chapter 43, Part 2. All right, we'll talk to you soon. Bye.